Welcome to Epstein Becker Green's Employment Law This Week podcast. I'm George Whipple. On July 4th, 2025, when most of us were celebrating Independence Day, the One Big Beautiful Bill Act was signed into law. Between cuts to Medicaid and limiting taxes on tips, there are many provisions of this sweeping law that impact employers. This week, we focus on the provisions that will have the most immediate impact: changes to employee benefits and executive compensation. Epstein Becker Green's Lucas Peterhans tells us more about the changes to employee benefits.
After almost 4 decades remaining unchanged, the One Big Beautiful Bill raised the Dependent Care Flexible Spending Account limit to $7,500. Concerning education policies for employers, the act makes permanent an employer's ability to make student loan repayments for employees on a tax-favored basis.
During negotiations, the House and Senate also considered many different proposals for expanding health savings accounts.
In the final version, a recently expired COVID-era safe harbor was made permanent, allowing a high-deductible health plan coverage of telehealth services before a participant has met their deductible. Additionally, with certain restrictions, participants in a high-deductible health plan with a health savings account can now participate in direct primary care agreements. Finally, the types of high-deductible health plans that are compatible with health savings accounts were expanded to include bronze and catastrophic plans that are offered in the individual market on an exchange.
Epstein Becker Green's Elliot Katz describes the changes that employers can expect when it comes to executive compensation, now that the bill has become law as the One Big Beautiful Bill Act.
With respect to executive compensation, the OBBBA impacts two parts of the tax code. Number one, Code Section 162M, which provides a limit on the ability of publicly held companies to deduct compensation to what's referred to as specified covered employees. And there's also an impact on Code Section 4960, which imposes an excise tax on compensation exceeding $1 million paid to covered employees of tax-exempt entities.
The law expands the definition of covered employee significantly to include any employee of a tax-exempt entity. That means every employee would potentially be subject to the excise tax.
The employee benefit and executive compensation provisions in the One Big Beautiful Bill have various effective dates, with some starting in 2026 and others retroactively applying to the start of this year. Employers should work with legal counsel to discuss the act in more detail to ensure their current policies comply with its requirements and to consider whether they want to include any new benefit offerings moving forward.
Thanks, Elliot and Lucas. For a complete overview of all the impacts employers can expect, Elliot, Lucas, and their colleagues in the EBG benefits team published a comprehensive article in the Epstein Becker Green Workforce Bulletin. Required summer reading for employers who want to be prepared. Thanks for listening, and we'll see you next time.
This podcast is presented by Epstein Becker Green, PC. All rights are reserved. This audio recording includes information about legal issues and legal developments. Such materials are for informational purposes only and may not reflect the most current legal developments. These informational materials are not intended and should not be taken as legal advice on any particular set of facts or circumstances, and these materials are not a substitute for the advice of competent counsel. The content reflects the personal views and opinions of the participants. No attorney-client relationship has been created by this audio recording. This audio recording may be considered attorney advertising in some jurisdictions under the applicable law and ethical rules. The determination of the need for legal services and the choice of a lawyer are extremely important decisions and should not be based solely upon advertisements or self-proclaimed expertise. No representation is made that the quality of legal services to be performed is greater than the quality of legal services performed by other lawyers.